siblings, one house, zero agreement. That is the situation I walk into more than almost any other in probate real estate. Selling inherited property with multiple owners. It is one of the most emotionally charged, legally complicated, and financially costly situations a family can face. If you are an heir to a property right now and not everyone is on the same page, this video is for you. Because what you don't know about co-ownership can cost your family everything. When one person inherits a property, the path forward is straightforward. When 2, 3, or 4 people inherit that same property, every decision multiplies in complexity. Think of it like a business partnership you never signed up for. They're getting louder. Overnight, you and your siblings or cousins, or in some cases, people you barely know, become co-owners of a real asset with real value and real legal obligations attached to it. And here is the part most families don't realize until it's too late. Every single co-owner has rights, and those rights can work for you or against you, depending on how this is handled. Today, I'm walking you through exactly how this works, what your options are, and how families in Orange County navigate this every single week without destroying relationships or losing money in the process. This is not legal advice. I'm not an attorney, but I work alongside probate attorneys every day, and I'm going to give you the framework that helps families move forward. When multiple heirs inherit a property, one of 2 things is happening legally. Either the property is still inside the probate estate, meaning the court and the executor control the process, or the property has been transferred to the heirs, meaning the co-owners control the decisions. Which situations you are in matters enormously. If you are still in probate, the executor may need court approval before a sale can happen. The heirs do not simply vote and decide. There is a legal process that governs the timeline and the terms. If the property has already transferred to the heirs, then in most cases, all co-owners who hold legal title must agree before the property can be sold. That word "all" is where families get stuck. One heir who says no can bring the entire process to a stop. Now here is something important to understand before we go further. The way title is held matters. Joint tenancy, tenants in common, community property, each one creates different rights and different rules. That is exactly why having a probate attorney involved from the beginning is not optional. It is the foundation everything else is built on. If you do not have a probate attorney yet, this is the step 1 before everything else. Let me tell you what I actually see happening in these situations, because it's rarely just about the house. The most common reason heirs can't agree is that they are each in a different financial position. One sibling needs the money now. Another wants to hold the property and rent. A third wants to move in. And a fourth lives out of state and just wants it resolved. 4 different life situations, 4 different answers to the same questions. The second most common reason is that the home carries emotional weight. It was a family home. Someone grew up there, someone is not ready to let go, and grief has a way of attaching itself to real estate in ways that make practical decisions feel like personal betrayals. The third reason, and this one catches families off guard, is an unequal contribution. One sibling has been paying the property taxes, the utilities, the maintenance. They feel they are owed money. Another sibling disagrees. Now you have a financial dispute layered on top of an emotional one. This is where families need a coordinator. someone who understands the emotional weight of the situation and the practical steps that move things forward without making it worse. This is the role I fill, and I will tell you more about that in a few minutes. Let's start with the best case scenario. All heirs agree they want to sell. Even in this case, there are decisions that need to be made carefully. Option 1, sell as is, fast close, no repairs, discount price. Works well when the state needs to close quickly or the property needs significant work. Option 2, light prep before listing. Fresh paint, clean out, odor removal, minor repairs. Usually a small investment that returns significantly more at closing. For most probate properties, this is a sweet spot. Option 3, one heir buys, the others out. This is called a sibling buyout, and it happens more often than people think. One person wants to keep the house. Maybe they are living there. Maybe it has sentimental value, and they purchase the other heir shares at fair market value. This requires an independent appraisal and careful coordination between the parties, their attorneys, and often a lender. Whichever path you choose, the financial outcomes depends entirely on how well the process is coordinated. That means having your probate attorney aligned, your CPA advising on tax implications, and a real estate professional who understands probate guiding the property decisions. Now for the harder conversations. What happens when heirs cannot reach an agreement and one person is blocking the sale? In California, the law provides a legal remedy called a partition action. Any co-owner can file a partition action asking the court to intervene. The court can order the property sold, regardless of whether all heirs agree, and the proceeds divided among owners according to their shares. Here's the reality of a partition action. It resolves the deadlock, but it is slow, it's expensive, and its public attorney fees come out of the proceeds. The timeline stretches and the family relationship often does not survive it. Partition is the last resort, not a first move. Before it gets there, there are steps that can resolve the situation without involving a judge. Mediation with a neutral third party, a structured family conversation facilitated by someone who understands both the legal framework and the emotional dynamics. A buyout offer that gives the reluctant heir what they actually need, which is often not money, but acknowledgement. I have sat in rooms where families went from complete deadlock to a signed agreement in a single conversation because someone finally asked the right questions and listened to the answers. Here is something every heir in this situation of selling inherited property with multiple owners needs to understand. Every month of disagreement costs money. The property taxes keep coming. The homeowner's insurance keeps billing. If there is a mortgage, those payments do not pause for family conflict. Utilities, maintenance, security, the carrying cost on a vacant probate property add up fast. And here is the one that surprises people most: deferred maintenance. A roof that needed $4,000 in repairs 6 months ago may need $18,000 today. A slow leak that went unaddressed becomes a mold situation. Deferred maintenance compounds the way debt compounds, quietly and then all at once. I also help coordinate that estate cleanout, personal property organization, and liquidation of items inside the home. Because those decisions also get delayed when heirs disagree, and every week of delay is another week of carrying cost. The longer this sits, the smaller the check everyone gets in the end. This is not an opinion, that is the math. If you are in the middle of a co-ownership situation right now, Here is the clear path forward. Step 1, get a probate attorney involved. If you do not already have one, the legal structure of your specific situation determines everything else. Step 2, an independent property valuation. When heirs disagree about value, an independent appraisal removes the argument. Numbers are neutral. Step 3, have an honest conversation about what each heir actually needs, not what they want to get out of the property, what they need. Those are often different things, and the gap between them is usually where the agreement lives. Step 4, bring in a coordinator who has already done this before. As a licensed realtor who works specifically on estate and probate properties in Orange County, I coordinate the full process, from the attorney and CPA alignment through the cleanout, personal property liquidation, contractors prep, listing, and closing. I work with cleanout crews and estate liquidators who handle these situations with care. I have contractor connections for interior and exterior work, including odor and spot treatment. I help with organizing donation coordination and moving services. I work alongside your legal and financial team, so everyone is pulling in the same direction. My job is to make complicated processes feel manageable, especially when the family is already dealing with grief. If you're navigating co-ownership situations, you want to talk through your specific circumstances. No pressure, no sales pitch. The link in the description goes directly to me, and if this video helped you understand your situation more clearly, please share it. There is another family out there right now who needs exactly this information. I will see you in the next one.